For more on this conversation, we're now joined by Tumelo Mashabela, a patent attorney at Tshaya Mashabela Attorneys. Tumelo, thank you so much for joining us this evening. It seems as if every time the people rooting for the underdog, every time that Mr. Makate celebrates, Vodacom hits back, and now they're hitting back again and heading to the Constitutional Court. Is there ever going to be an end to this David versus Goliath legal battle?
Thanks, Masa. I think it is coming to an end. But I think we all know that, the law does take time. But in this case, I would say patience is a virtue. From what you've seen, it looks like Makate might have moved from 47 million to the possibility of getting a couple of billions. So it is, I think it is coming to an end. And Vodacom is entitled, like any other, person in South Africa, to use all legal avenues that are available to them. But I think it is coming to an end. But I'm not sure if you're also aware of this other case that, it involved the Solomon Linde family, where in that case they were against Disney. The song was created, and it was about a song. The song was created in the 1930s, and Disney started using it in the 1990s. However, the settlement was eventually awarded around 2006. So it does take a while, especially on IP cases, but I think it is coming to an end.
Geez, using that example, that's over 60 years long. I'm sure people like Mr. Makate don't want to hear that kind of information as well. But thankfully, as you're saying, it is coming to an end, because after the ConCourt, should the ConCourt rule in his favor, Vodacom has nowhere else to go.
Yes, unfortunately, they wouldn't. And like I said, I mean, they are entitled to take it to the ConCourt. But the issue is, what is the constitutional issue that they are bringing to the ConCourt? And where I'm sitting, I'm failing to see it, because, the SCA has actually put down the judgment and said they must pay between 5 to 7.5% of the revenue that they have received for the past 18 years. And to take any matter to the ConCourt, there must be a constitutional issue that you are taking to the ConCourt. But also, as we all know, the ConCourt is our highest court. And if they lose at the ConCourt, that's it. They will have to eventually pay what is supposed to be paid to Mr. Makate.
Now, as you mentioned as well, it is, of course, Vodacom's right to pursue the legal route as well. But taking a look at this 18-year-long legal battle and the monies that are involved, would you say that it was even worth challenging it so rigorously by this corporate giant?
It's a lot of money that is involved. For example, if you look at what the CEO of Vodacom offered Makate, he offered 47 million rand. But that 47 million rand was offered on a 5-year contract. And now, if the fact that now the court is saying that you need to take into account all these other years, it means that it's quite a lot of money. And as Vodacom, like I said, to have to cough out that amount of money, if I was in their shoes, I would do whatever it takes to try to find a way, either to pay less or not to pay. But also on Mr. Makate, my understanding is that this, long litigation matter has been funded, meaning that there are people or investors that have actually funded, this litigation matter for Mr. Makate. So also those people will need to be paid. So it also makes sense for them not to just take whatever that, Vodacom is saying, and to make sure that Mr. Makate eventually get compensated reasonably. And if you remember the first ConCourt judgment on this case, the court told Vodacom to negotiate and pay Mr. Makate in good faith. However, it doesn't look like Vodacom acted in good faith, because there were certain contracts that were not disclosed. So I think for Vodacom, for both of them, it makes sense. Like I'm saying, for Mr. Makate, it has been years, and there are people or companies that have invested and trying to assist him in this litigation matter. So it makes sense for them to continue to push until they get as much as money as possible. However, it also makes sense for Vodacom to also continue pushing because it's a lot of money. 5%, between 5 and 7.5% of all revenues that you got from the Please Call Me idea for the past 18 years is quite a lot of money. So I think for both parties they had to keep on pushing.
I mean, it's taken 18 years, and you're saying we're finally reaching finality with this. Do you think before the end of the year, Mr. Makate can finally be laughing all the way to the bank and getting his last laugh?
I mean, I can't say like I said, my issue is if Vodacom is saying they're taking this matter to ConCourt, what is the constitutional issue that they are basing this on? So I don't know what would be the issue, that Vodacom is going to use in this regard. But I mean, the court said that the order of the SCA is supposed to be taken into effected within 30 days. So we are hoping that maybe if Vodacom doesn't go to the ConCourt, they will make sure that they pay Mr. Makate. So honestly, where I'm sitting, I cannot say whether or not by the end of the year this matter would be settled. But one thing that I would want to mention, Masa, and it's that this whole case has illustrated the importance of intellectual property and the value of it. I mean, if we look at the fact that the person, Mr. Makate, at first, was offered 47 million rand on intellectual property that he created. Now he stands a chance of getting billions. It shows that, individuals as well as, it's actually a lesson rather to individuals and companies about the importance of IP and that IP is a crucial asset. And if you protect it and manage it effectively, it can actually generate quite a lot of money within your business. Although this case is not about IP per se, it was mainly about contract. But now we are looking at the value of that particular IP that Mr. Makate created. So for me, I think it shows evidence that intellectual property is a valuable asset within a business.
And Tumelo, speaking of the importance of IP, the fact that this matter has taken this long, is it concerning for anyone who would like to use the legal system in patent law cases?
It is concerning, but every case is different. So within patent law, and based on history, most of the companies that have, litigated on patent matters could be on patent infringement matters. Those companies are mainly your big pharmaceutical companies, and it is because they have the money and they have the time. However, for any other person, it's really not a relatively cheap exercise. It's very costly. I mean, just a normal, let's say, patent infringement matter, you can be charged between 4 to even 10 million rand. For a litigation matter. It can even be worse if there's an appeal. And although there is what we call a contingency fee agreement, where an attorney can assist you and take about maximum of 25% on the award that you will receive, that contingency agreement is normally not used within the patent system. So it is concerning, and for us, most of our clients, we always try to find a way to negotiate and try to settle where possible. And I always advise clients that, take the route of litigation only if you have to, but it's not something that you can take lightly because it is a very expensive and time-consuming exercise, especially because it involves a lot of expert witnesses. It involves, it depends on the volume of evidence that is available. So there's quite and as well as whether you're using senior counsel or junior counsel. So there's quite a lot of aspects that affects, that will have an impact on the length of the case as well as the cost involved in that particular case.
How do you advise your clients to mitigate against that? Because it seems that, they really would be coming from a back foot if you're going up against a giant organization that has all the means, all the resources, and all the legal resources as well to take this matter. How does one mitigate against the ideas not being stolen?
So the main thing for us is to make sure that you protect your idea. For example, if you come up with an invention, I always tell clients that try to at least file a provisional patent application. In that way, by the time you go and disclose or you go and disclose the idea to the big company, you have already reserved your rights. So it's going to be relatively easy for me as a patent attorney to illustrate to that company that it is your idea because we have filed with the CIPC. So protecting your technology or invention is the first step. And I know a lot of entrepreneurs, they would say, but Tumelo, sometimes it's intimidating to have to go to talk to a big company and you want them to fund you and, we end up disclosing our information. But I always say, you need to look at the value. If you see your invention as very valuable, I would highly suggest that file at least a provisional patent application at the CIPC, which is something that you can even do yourself. You don't need a patent attorney to do it for you. So it's relatively cheap to do it for yourself. And I recommend that people do that, take that route, file a patent application, because if there's a patent application, like I said, then it's going to be very easy for us to prove that it is your invention and it is not, the big giant's invention.
Well, thank you so much for your insights and your time and for joining us on Newzroom Africa. That was patent attorney and director at Tshaya Mashabela Attorneys, Tumelo Mashabela.